started. We're going to go ahead and get started here. If you're still coming in, just continue to file in. Feel free to get up and get some more food. I want to thank all of you for attending today. I also want to extend a thanks to Thomas Barr for setting this up, and also to the St. Thomas More setting this up. I'd also like to thank the Templeton Foundation for the grant that provided the food for today. Today we have two speakers. First, we have Dean Don Welch. He'll be providing commentary. He really needs no introduction to the law school, as he is a dean here, has written a book on the history of the law school, and he also holds a joint appointment as a professor of religion here, and is no stranger to all of us here. Secondly, we have Judge William H. Pryor. Judge Pryor is a judge on the U.S. Court of Appeals for the 11th Circuit. His office is in Birmingham. He went to Tulane Law School, where he had the highest grade point average in civil law courses. He was a member of the Tulane Law Review, and he has written and published extensively, although never in a Vanderbilt journal. But he was appointed to the U.S. Court of Appeals in 2004 and confirmed by the Senate in 2005. Please join me in welcoming him here today.
Thank you, Daniel. It's nice to be back at Vanderbilt. I think it's third or fourth time that I've had the honor of speaking here. And I feel like I've made some progress. Usually if you speak at a law school event, you think it's a pretty good deal if everyone has the opportunity to eat pizza. I knew I'd hit the big time a couple of years ago when I spoke at Yale and debated a friend of mine, Professor Stephen Carter, and it was advertised around the law school as a non-pizza dinner will be served. Apparently I've hit the big time again at Vanderbilt because we have a non-pizza dinner as well. My topic today you've all heard about. In his immortal play, A Man for All Seasons, Robert Bolt provides a fictional account of an argument between Sir Thomas More, who served as the Chancellor of England and would later become the patron saint of lawyers and judges, and his son-in-law, William Roper. Their argument is about the demands of fidelity to both law and morality. In the course of the argument, More pleads, "The law, Roper, the law. I know what's legal, not what's right, and I'll stick to what's legal." Roper then makes two provocative charges against Thomas More. First, Roper asserts to More, "Then you set man's law above God's." More responds in the negative, "No, far below, but let me draw your attention to a fact. I'm not God. The currents and eddies of right and wrong which you find such plain sailing I can't navigate. I'm no voyager. But in the thickets of the law, oh, there I am a forester. I doubt if there's a man alive who could follow me there, thank God." Later, Roper charges, "So now you give the devil benefit of law." To that charge, More responds in the affirmative and asks a question of Roper. "Yes, what would you do? Cut a great road through the law to get after the devil?" Roper then falls into the trap when he answers, "I'd cut down every law in England to do that." More then offers the most memorable lines of the entire play. "Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The laws all being flat. This country's planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down, and you're just the man to do it, do you really think you could stand upright in the winds that would blow then? Yes, I'd give the devil benefit of law for my own safety's sake." Robert Bolt's portrait of St. Thomas More offers lawyers and judges the right role model. I've been asked today to reflect on my personal experiences, both formerly as a state attorney general and as a nominee for a federal judgeship, who was embroiled in controversies about the potential conflict of moral and legal duties. The stakes of those controversies, thankfully, were not nearly as high as those that led to the execution of St. Thomas More, but they were at least high drama in the contemporary arena of American law and politics. In each instance, the law offered me the right path to follow. My first experience came in June 2003, 2 months after the President nominated me to serve as a United States Circuit Judge. That nomination was controversial for several reasons. Among them, my public statement then as a politician that Roe versus Wade was the worst abomination of constitutional law in our history. My defense as Attorney General of Alabama of a law that made sodomy a crime. And even my decision as a parent to plan a family vacation at Disney World so as not to coincide with the Gay Day festivities at that park. During my confirmation hearing, a few members of the Senate Judiciary Committee raised questions about what they called my deeply held beliefs and whether I was asserting an agenda of my own, a religious belief of my own, inconsistent with separation of church and state. When then committee chairman Senator Hatch responded to these statements by asking about my Catholic faith and then asserting that in every case he could see I had, quote, in his words, followed the law regardless of my religious beliefs, 2 other senators objected to Chairman Hatch's reference to my religion. Later that summer, an interest group sponsored political advertisements that described opponents of my confirmation to the federal bench as engaged in discrimination against me based on my Catholic faith. The advertisement portrayed a sign that read, "Catholics need not apply," hanging on a door to a federal courthouse. That advertisement created a furor in the Senate and a lively debate in national newspapers and magazines. My second experience came at the end of that same summer when Roy Moore, who was then the Chief Justice of Alabama, refused to obey an injunction of a federal district court that required the removal of a monument of the 10 Commandments from the rotunda of the Alabama State Judicial Building. I was Attorney General of Alabama then, and I publicly disagreed with Moore and assisted the Associate Justices of the Supreme Court of Alabama in ensuring compliance with the injunction. After the Alabama Judicial Inquiry Commission then filed charges of misconduct against Roy Moore, I personally prosecuted the charges in the Alabama Court of the Judiciary, which unanimously granted my request to remove Moore from his judicial office. Throughout these experiences about the potential conflict of legal and moral duties, my perspective has been that I should follow the example of St. Thomas More. My Catholic faith is the foundation of my worldview, and my judicial duty is governed from beginning to end by the law. Faith properly informs the religious lawyer or judge, and morality is not in tension with fidelity to the law. I will first address my perspective about the controversy that affected my judicial nomination, the role of religion in judging. Religious faith properly informs me as a judge in my fidelity to my judicial duty in at least 4 ways: in my understanding of my oath of office, in my moral duty to obey lawful authority, and in my responsibility to work both diligently and honestly. Each of these ways is motivational. That is, each concerns the judge's duty to perform his work well. None involves using religious doctrine to decide a case in conflict with the law. The most fundamental way that faith properly matters to me as a judge is my understanding of my judicial oath of office. The framers required in Article 6 of the Constitution that officers of our government, including judges, be bound by oath or affirmation to support the Constitution. In the next part of that clause, they provided that no religious test shall ever be required as a qualification to any office or public trust under the United States. The framers thought that the particular religious beliefs of the judge should not matter, but that it was crucial for the judge to have his conscience, as informed by those beliefs, bound by the Constitution. Many of the states had a different rule. Delaware, for example, in Article 22 of its Constitution of 1776, required officers to profess faith in God the Father and in Jesus Christ, his only Son, and in the Holy Ghost, one God, blessed forevermore, and to acknowledge the Holy Scriptures of the Old and New Testament to be given by divine inspiration. Vermont in Chapter 2, Section 9 of its Constitution of 1777, required legislators to declare, "I do believe in one God, the creator and governor of the universe, the rewarder of the good and punisher of the wicked, and I do acknowledge the scriptures of the Old and New Testament to be given by divine inspiration, and own and profess the Protestant religion." I'm especially grateful that last line of the Vermont Constitution did not become part of the federal Constitution. Lots changed in Vermont. During the ratification process, some Americans during the ratification process objected to the ban of religious tests, as many Protestants feared the election or appointment of Catholics to federal office. James Iredell, a delegate to the North Carolina Convention, provided my favorite rejoinder to these objections when he rose to defend the ban on religious tests on July 30th, 1787. His words were especially memorable for Catholics. Iredell said, "I met by accident with a pamphlet this morning in which the author states as a very serious danger that the Pope of Rome might be elected president. I confess this never struck me before, and if the author had read all the qualifications of a president, perhaps his fears might have been quieted. No man but a native, and who has resided 14 years in America, can be chosen as president. I know not all the qualifications for a pope, but I believe he must be taken from the College of Cardinals, and probably there are many previous steps necessary before he arrives at this dignity. A native of America must have very singular good fortune, who, after residing 14 years in his own country, should go to Europe, enter into Romish orders, obtain the promotion of cardinal, afterwards that of pope, and at length be so much in the confidence of his own country as to be elected president. It would be still more extraordinary if he should give up his popedom for our presidency. Sir, it is impossible to treat such idle fears with any degree of gravity." The framers' general understanding was that prescribing religious tests did not necessarily remove the religious significance of the general oath. James Madison, the father of the Constitution, for example, explained in a letter to Edmund Pendleton in 1787 that an oath should make a religious test unnecessary. Madison wrote, "Is not a religious test, as far as it is necessary or would operate, involved in the oath itself. If the person swearing believes in the supreme being who is invoked and in the penal consequences of offending him, either in this or a future world or both, he will be under the same restraint from perjury as if he had previously subscribed a test requiring this belief. If the person in question be an unbeliever in these points and would notwithstanding take the oath, a previous test could have no effect. He would subscribe it as he would take the oath without any principle that could be affected by either." Madison's argument, expressed by others as well, was that a religious believer would take an oath seriously without need of a religious test, and that a religious test could be declared by an unprincipled atheist without fear of punishment after death. Either way, a religious test was unnecessary. When I placed my left hand on the Holy Bible and swore to perform all the duties incumbent upon me as the United States Circuit Judge under the Constitution and laws of the United States, and swore that I would well and faithfully discharge the duties of the office on which I'm about to enter, so help me God, my conscience was and remains affected by my religious beliefs. Were it not so, what would be the point of placing my hand on the Bible or ending the oath with the declaration, "So help me God"? Taking a false oath is a violation of the second commandment, not to take the name of the Lord in vain. As the Catechism of the Catholic Church explains, taking an oath or swearing is to take God as witness to what one affirms. It is to invoke the divine truthfulness as a pledge of one's own truthfulness. An oath engages the Lord's name. My entire understanding of my judicial duty flows from taking my oath seriously. James Madison and the other framers of the Constitution expected nothing less. My religious faith also informs my perspective on my judicial duty to obey lawful authority. I believe I have a moral obligation to obey the government and its laws. Before I became a judge, this perspective informed my decision as then the Attorney General of Alabama to obey the federal injunction that required the removal of the monument of the Ten Commandments in the Alabama State Judicial Building. My moral duty to obey the law pertains to my judicial duty now, just as it pertained to my executive duty then. My faith informs my judicial duty in a third way, by inculcating me with a belief in the moral duty to work. I believe that work is, in a real sense, a form of prayer. This religious belief motivates my commitment to my oath to well and faithfully discharge the duties of the office of a circuit judge. The final way my faith informs my performance as a judge is by teaching me to be honest. The moral duty of honesty requires both truthfulness in communication and reasoning and respect for the property of others. This duty is reflected in the commandments against bearing false witness and stealing, respectively. Regarding the former, the Catechism has the following strong words about the necessity for truth in a judicial system. When it is made publicly, a statement contrary to the truth takes on particular gravity. In court, it becomes false witness. When it is under oath, it is perjury. Acts such as these contribute to the condemnation of the innocent, exoneration of the guilty, or the increased punishment of the accused. They gravely compromise the exercise of justice and the fairness of judicial decisions. Although my religion properly informs and motivates me to be faithful to my oath of office and to my moral duties, to obey the government and its laws, to work both diligently and honestly, there is a limit to the relevance of religion in the performance of my judicial duty. That limit is defined by the very nature of my judicial authority. Properly understood, the exercise of my authority as a federal judge is governed by the law alone, and that understanding is where the real controversy exists in the contemporary debate about judicial authority. As a judge, I'm not given the authority to use a personal moral perspective to update or alter the text of our Constitution and laws. The business of using moral judgment to change the law is reserved to the political branches, which is why the officers of those branches are regularly elected by the people. A judge's task is limited to serving, in Chief Justice Roberts' words, as an umpire, so that controversies between citizens and officers of their government may be resolved based on the law. For that limited task, a federal judge is granted a privilege designed to secure his independence, life tenure with no reduction in salary, at least except by inflation. An officer of a political branch, such as Congress, is free to propose changes in the law that conform with his perspective of morality as informed by his religion. For centuries, members of Congress have supported a variety of laws on this kind of basis, whether to abolish slavery, withdraw troops from foreign wars, abolish child labor, guarantee civil rights, provide assistance to the poor and sick, protect marriage, or even prohibit the sale of intoxicating liquors. The changing of laws enacted by political authorities is not a judge's task. The duty of a judge is the application of those laws in controversies within the jurisdiction of the courts. I do not mean to suggest that the task of judging is either mechanical or easy. The meaning and application of the law is sometimes difficult to discern, which is why judges in good faith sometimes disagree. The duty to administer justice requires the exercise of judgment, but not the employment of religious doctrine as a source of authority to supplant or evade the law when judging becomes difficult or its outcome undesirable. A judge who is motivated by moral duties to fulfill his oath and obey the law must strive to be as objective as possible using traditional methods of construction, reliance on precedent, and legal reasoning. This limited understanding of the judicial role has served our nation well for more than 2 centuries. It has allowed our judiciary as a separate branch to perform, when necessary, its vital role of demanding compliance with the Constitution. In short, the rule of law that flows from the separation of powers has preserved our freedom. With that understanding of my moral and legal duties in mind, allow me to return to my experience as then the Attorney General of Alabama to illustrate how my understanding guided me. In the days following the removal of his monument of the 10 Commandments, Chief Justice Roy Moore and his prominent supporters advanced 3 arguments against those of us who complied with the federal injunction. They argued, first, that we had a moral duty to acknowledge God that required us to disobey the injunction. Second, as they surrounded the state judicial building in hopes of preventing the removal of the monument, Moore's prominent supporters compared their struggle with that of the civil rights movement led by Dr. Martin Luther King Jr. In turn, they compared those of us who complied with the federal injunction with the defenders of racial segregation. Finally, Moore argued that we had a duty to disobey the injunction as we would, he argued, if the injunction had allowed slavery. I disagreed with Moore. I argued that I had a moral duty as a Christian to obey the federal injunction. There was no moral justification for civil disobedience. My oath to uphold the U.S. Constitution required me as Attorney General to obey the injunction without regard to whether I agreed with the basis for that injunction. My moral duty was not in conflict or even tension with my legal duty. My Christian duty instead provided the foundation for my public duty. I explained that the Christian duty to obey the government and its laws is clearly expressed in the New Testament. In St. Matthew's Gospel, Jesus gave a provocative lesson about the moral duty to obey the government. Then give to Caesar what is Caesar's, but give to God what is God's. In his epistle to the Romans, the Apostle Paul taught, let every person be subordinate to higher authorities, for there is no authority except from God, and those that exist have been established by God. And in his first epistle, Peter wrote, be subject to every human institution for the Lord's sake, whether it be to the king as supreme or to governors as sent by him for punishment of evildoers and the approval of those who do good. During the several years that I served as Attorney General, I defended the constitutionality of depicting the Ten Commandments in a courthouse. I assisted the governor in creating a display of several foundations of our law, including the Ten Commandments, in the old Supreme Court Library of the state capitol. I publicly agreed with the opinion written by the late Chief Justice William Rehnquist that the Ten Commandments, quote, have made a substantial contribution to our secular legal codes. Nevertheless, in the controversy about Roy Moore, I was obliged, morally and legally, to obey the injunction of the federal court. Removing the monument of the Ten Commandments from the building of the government did not require me or another official to violate a moral duty. Jesus Christ did not command anyone to maintain a monument of the Ten Commandments in the rotunda of a courthouse. The legality of a monument in the rotunda of Caesar's courthouse is a question for Caesar. What about the second accusation? Did compliance with the injunction violate the civil rights of Christians? Were the protesters outside the state judicial building engaged in rightful civil disobedience? Was Chief Justice Moore the new Dr. King and I the modern-day Bull Connor? The answer to all these questions is no. The authoritative text on this issue, I submit, is the letter written by Dr. Martin Luther King Jr. from the Birmingham City Jail on Easter weekend, 1963. The letter was addressed to liberal white clergy of Birmingham who opposed segregation but did not support Dr. King's nonviolent protest against racial discrimination. The white religious leaders argued that as a Christian, King had a duty to obey the government. Dr. King responded that he was not obliged to obey an immoral or unjust law. King argued, based on the writings of St. Augustine and St. Thomas Aquinas, that an unjust law is a human law that is not rooted in eternal law and natural law. King contended that segregation statutes are unjust because segregation distorts the soul and damages the personality. He explained, a law is unjust if it is inflicted on a minority that as a result of being denied the right to vote had no part in enacting or devising the law. He concluded that a law is unjust when it is used to deny citizens the First Amendment privilege of peaceful assembly and protest. Dr. King's case was that segregation treated black persons as less than citizens and gave them no political recourse to remedy their injury. Then King explained the difference between unjust defiance and just civil disobedience. He wrote, "In no sense do I advocate evading or defying the law, as would the rabid segregationists. That would lead to anarchy. One who breaks an unjust law must do so openly, lovingly, and with a willingness to accept the penalty. I submit that an individual who breaks a law that conscience tells him is unjust and who willingly accepts the penalty of imprisonment in order to arouse the conscience of the community over its injustice is in reality expressing the highest respect for law. Dr. King's letter belies any comparison of the civil rights protest in 1963 in Birmingham and the protest of Roy Moore and his supporters in 2003 in Montgomery. The injunction to remove the monument did not distort the soul or personality of Christians, because Christianity is not dependent upon the presence of a monument in a government building. The injunction did not represent a government denial of political recourse for Christians. Christians still enjoy the constitutional rights to vote, hold office, speak, exercise our faith, and assemble. Indeed, the election of Roy Moore and the peaceful protest for 2 weeks outside the state judicial building, complete with extensive freedom of the press, illustrated the vitality of the civil rights of Christians. The most fundamental distinction between Dr. King's example and Roy Moore's examples is the difference between defiance of the law and civil disobedience. Dr. King expected the law he called unjust to be enforced against him, but Roy Moore and his supporters said they expected our state officials not to enforce the injunction. Dr. King was a private citizen who, in his words, lovingly accepted the punishment of an unjust law. But Roy Moore was a public official who refused to obey and sought to evade any punishment or responsibility. A private citizen may, in extreme circumstances, engage in civil disobedience by accepting the punishment of an unjust law. But a public official who swears to uphold the law has no such option. Perhaps the greatest irony was the reaction of Roy Moore's supporters following the removal of the monument from the rotunda. When we complied with the injunction, the supporters of Roy Moore called on me to resign. As a public official, if I am ever unable to fulfill my oath and obey the law, then I should resign. The duty of a public official brings me to my response to Roy Moore's final contention, that we were obliged to disobey the injunction, as he argued we would disobey an order allowing slavery. After the associate justices unanimously ordered the building manager to comply with the injunction, Roy Moore said, "If the rule of law means to do everything a judge tells you to do, we would still have slavery in this country." This assertion is contrary to the American history of the abolition of slavery, especially the example set by the great emancipator, Abraham Lincoln. An infamous decision of the Supreme Court, of course, promoted slavery. In 1857, the Supreme Court decided in Dred Scott that the Missouri Compromise, which prohibited slavery in Western territories, was unconstitutional and that blacks were not citizens. Abraham Lincoln argued that Dred Scott was wrongly decided and must be opposed. But Lincoln's perspective about the proper response to Dred Scott is instructive. In October 1858, Lincoln explained in one of his famous debates with Stephen Douglas as follows: "We oppose the Dred Scott decision in a certain way. We do not propose that when Dred Scott has been decided to be a slave by the court, we as a mob will decide him to be free. We do not propose that when any other one or 1,000 shall be decided by that court to be slaves, we will in any violent way disturb the rights of property thus settled. But we nevertheless do oppose that decision as a political rule which shall be binding on the voter to vote for nobody who thinks it wrong, which shall be binding on the members of Congress or the President to favor no measure that does not actually concur with the principles of that decision. We propose so resisting it as to have it reversed if we can, and a new judicial rule established on this subject." Lincoln explained that there were two ways of opposing a decision of a court allowing slavery. One method of opposition was illegitimate and to be avoided. The other method of opposition was legitimate and necessary. The illegitimate opposition was defiance of a final order of a court. Lincoln recognized that the Constitution in Article 3 created a federal judiciary to resolve disputes, particularly involving the interpretation of the Constitution. Upon the resolution of their dispute, the parties to the lawsuit, in Lincoln's view, were obliged to follow the orders of the court, and non-parties were obliged to respect the resolution of that dispute between the parties. Public officials sworn to uphold this constitutional framework for resolving disputes were obliged to enforce the final orders of this process as between the parties, without regard to the public official's opinion of the correctness of the ruling. The legitimate method of opposition, according to Lincoln, was political. Voters should support candidates who would work to end slavery, elected representatives should enact laws to end slavery, and the judiciary should, in proper cases. Lincoln also supported another more provocative method of opposition. Lincoln refused to allow the Dred Scott decision to bind his administration. Lincoln required his administration, for example, to issue a passport to a black student and a patent to a black inventor. Lincoln supported policies of the government that challenged the continued application of Dred Scott because Lincoln considered those policies constitutional, notwithstanding the erroneous precedent in Dred Scott. As Lincoln explained in his inaugural address, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. When the judiciary interprets the Constitution erroneously, the American people still retain all the lawful tools of political opposition that President Lincoln employed. The American people can campaign for different policies. The American people can elect candidates who will enact their favored policies. Elected officials can appoint judges faithful to the rule of law. The American people can bring new cases before the courts and urge the overruling of erroneous precedents. If necessary, the American people can even amend the Constitution. But defiance of the law is not a remedy under the Constitution. Contrary to Roy Moore's argument, slavery did not end through the defiance of an injunction by a public official. Slavery was abolished following our bloody Civil War with the adoption of the 13th Amendment to the Constitution. The rebellion of the southern states set the wrong example of defiance. Many might say, and I would agree, that it is easy to see why Roy Moore was wrong to take the law into his own hands. Because our liberty depends on the rule of law, we are all bound to obey even when we disagree with the decisions of our courts. As St. Thomas More said, "The law, Roper, the law. I know what's legal, not what's right, and I'll stick to what's legal." But the controversy about Roy Moore raises another question. What about those who applaud or publish glowing editorials when other judges place their own different notions of morality above the law? That wrong can be done from either the right, as in the case of Roy Moore, or the left. The law is not a mirror that will always reflect our individual notions of right and wrong. For courts, questions about morality, including the death penalty, marriage, and family, for example, are to be resolved based on the law, not based on what a majority of lawyers or judges think the law should be. Legislators and voters may change the law and be informed by morality in that endeavor, but none of us has the authority to defy or subvert the law in the name of morality. Faced with the conflict of law and morality, we should follow the example of St. Thomas More, who resigned as Lord Chancellor after King Henry VIII left his wife Catherine for relations with Anne Boleyn, and the clergy surrendered the property of the church in England to the king. When the English Parliament passed the Act of Succession, which made Anne Boleyn's issue first in succession to the crown, St. Thomas More said he would swear to the succession, for it was the law of the land. But he refused to declare the supremacy of the king over the church. St. Thomas More recognized clearly his duty to render to God what belongs to him, while rendering to Caesar what belongs to him. In his devotion to duty, St. Thomas More paid the ultimate price. As he succinctly explained a moment before his execution, he died the king's good servant and God's first. St. Thomas More lovingly accepted the punishment of an unjust law like Dr. King did centuries later in America. Both St. Thomas More and Dr. King rejected the path of defiance, evasion, and subversion of the law. They recognized that path would lead, in Dr. King's words, to anarchy, when moral duty instead required the highest respect for the law. Those who would, like William Roper or Roy Moore, cut down the law to get after the devil, risk falling into his trap. When the devil turns around, where will they hide? The laws all being flat. For me, I will strive to follow St. Thomas More's example and give even the devil the benefit of law for my own safety's sake. Thank you. May God bless you.
We are indeed fortunate to have Judge Pryor with us today, who has lived these issues, these controversies. It is easy for those of us in this building to think abstractly, think theoretically, and it's helpful to have somebody remind us what things look like on the ground. I'm so appreciative of his remarks that my first instinct was just to say, amen. But then I feel like I wouldn't have earned my lunch if that was all that I did. So I'll make a comment or two that may stir some thinking around the edges, beginning with a couple of distinctions that he makes that I simply want to reinforce that are, I think, crucial. One is the distinction between criminality and civil disobedience, between acting outside the law and resistance to a law in a matter that is open, in which you're willing to accept punishment, as opposed to evading law, trying to undermine and obstruct law. And second, he makes a distinction between, I think, citizens and judges. If I hear him correctly, that judges have taken an oath that is more limiting on their ability to even engage in civil disobedience than would be the case for ordinary citizens. Although I would think that even ordinary citizens have some moral obligation to obey the law. So just pressing this distinction a little, can we think of any case, can we imagine any situation in which we would urge, approve a judge engaging in civil disobedience? Unfortunately, we have the example of Hitler's Germany in our history, which makes it maybe too easy to imagine cases where we would want a judge to try to undermine the legal regime, where they are part of a legal apparatus that is so corrupt that even the judge we would want to take this extra step. The moral authority for that, is something we need to think about. And what I would suggest or offer is an interpretation I've heard of the render under Caesar passage, which I find at least provocative. Jesus did say, render under Caesar the things that are Caesar's, and unto God the things that are God's. But a twist on that I've heard is from a theologian who explains that as he views that situation, Jesus is speaking in the midst of Roman authority, of people who have taken dominion over that area, perhaps in their view unfairly, unjustifiably, illegitimately, and that Jesus is speaking to people who understand that when he says, render under Caesar the things that are Caesar's, and unto God the things that are God's, that they understand that ultimately it's all God's. Everything is God's, ultimately. Now, that gives me pause, gives me something to think about. But I am also reminded, just as we've been told that bad cases make bad law, I think it's also the case that hard cases can distort moral reasoning. And fairly quickly, I find myself reeling in my imagination a little. And I guess first thinking about humility, what it would take for any of us on our own, what it would take for a judge on his own or her own to substitute his judgment, his conclusions, for what the legal regime has set forth. I remember a story that Kent Severud told, a dean here at Vanderbilt Law School not that many years ago, when the Soviet Union was breaking up and Russia was as a country trying to fashion a legal regime. He was one of the American lawyers who went over there, who talked with them some about the American legal system and described how it was possible for a judge in one part of the country to make a decision, and a judge 2,000 miles away would enforce that decision in a different jurisdiction. And he said he looked up at these lawyers there, these Russian lawyers, these former Soviet Union lawyers, and there were tears in their eyes because they had never experienced that kind of legal regime. They have never lived in that kind of legal system. And I think we do need to value that. We do need to realize that we don't want to cut down those trees. We don't want to create a situation in which obedience to the law is possible only when it's enforced by federal marshals, or only when troops have to be sent in to make judges obey the law, as well as to make citizens obey the law. The final thought I would leave you with is we have the distinction between private citizens. We have between those private citizens and judges who have taken an oath to uphold the law. One other type of person we might think about are attorneys. Where on this continuum might we place attorneys? Do attorneys have an obligation similar to judges? Do they have obligations more similar to ordinary citizens? And how do we parse those things out? So thank you for very thought-provoking topics, and I gather we're saving some time for questions and answers.
We have a few minutes left for questions. Should you wish to read the remarks of Judge Pryor's speech, it is available in the Harvard Journal of Law and Public Policy. So we'll open the floor for questions now.
Yeah, Judge, so are there any situations that you see out there right now where your religious beliefs will prevent you from deciding a case a certain way? So, for example, what if a young woman wants to bypass parental consent for abortion?
That's a great question. I'm a federal appellate judge, so I'm not going to have that kind of case where a minor goes before a state trial judge and asks for permission without the consent of parents to obtain an abortion. In my more than 6 years now of serving as a federal judge, I haven't come in that kind of conflict. I don't expect it to happen. I think the possibility of it happening is pretty remote. One thing I think you have to keep in mind, though, is what would be that kind of conflict that would really require a judge to be faithful to his conscience and obey a moral duty that is in conflict, that is in true conflict with the legal duty. If that conflict were to arise, I would think that the judge would have it as an option, if it's a relatively rare event, recusal in that particular case. I don't expect that to happen in my experience and what I do, but I can't imagine that could happen. The Catholic Church teaches that what you should consider is whether your cooperation with evil is classified, one way of describing it, as formal cooperation with evil. If I'm the lookout for the bank robber who's on the inside doing the heist, That's formal cooperation with evil. I share in his intended act and the result, and that is always wrong. I can't do that. That's not what judges do, though. When parties come before me and ask for a certain result dictated by the law, and I follow the law and apply the law, no one thinks that that means that I have shared the objective of the winning side in the legal controversy. I have done what the law requires. That doesn't necessarily mean that that's what I think is the best result. That, though, is called material cooperation with evil. And material cooperation with evil can be permissible so long as it's not proximate, that is, it's more remote, if it's dictated by the law. For example, we know that the mailman delivers all kinds of things. He's required by law to respect the confidentiality and requirements of the law to deliver holy Bibles and life-saving medicine, but also pornography. Does the mailman sin by cooperating with evil and delivering pornography? Well, no, because it's not what he wants necessarily delivered. He respects the rules that deliver all the good things as well, and it's that system that allows that to happen. But that doesn't mean that by delivering pornography that's something he is proximately, materially cooperating with evil, such that his behavior could be considered evil itself. Now, you raised the example of the trial judge in the state court allowing the minor bypass to have an abortion. Another example might be a state trial judge who actually makes the decision whether to enter a sentence. The judge is doing is dictated, I think, by objective legal criteria. I think, and where it's clear that that's what is governing the judge's decision, and that is not necessarily something that the judge would agree with the outcome. I think that the judge's decision could be morally defensible, but sometimes the law, and these two examples I think are the two toughest, really recall on the judge to make a moral kind of legal quasi-moral legal judgment. And I think that's a lot tougher question. It's not something, thankfully, I'm going to have to face. But I mean, Catholic theologians are in agreement that a federal appellate judge who, after a death sentence has been entered, is just reviewing a death case and resolving whether the Constitution has been followed in the trial proceedings. When the judge affirms, the judge is not in any way materially cooperating with evil that would be considered objectionable. But I think it's a tougher question for the two examples that we've talked about. Thankfully, I won't have to see either one in my role. Yes.
I think Dean Wells brought up a good point about where the attorneys fit into the spectrum. And Rich, what would your thoughts be on attorney?
Well, he brought up an issue, too, about judges. I'm going to answer it a little bit by first talking a little bit about that. I don't think that if a judge were to serve in Nazi Germany or Red China and was routinely called upon to enforce in a direct way morally evil results, that a Christian could do that in good conscience. I think you'd have to resign the office if you're going to be true to your moral duty. For lawyers, it's a similar perspective, but the perspective I talked about with formal and material cooperation with evil is at play as well. When you defend someone who's committed a crime, you've not in any way participated in their criminal activity, which has already occurred. When you test the state's case to make sure that the state proves that case beyond a reasonable doubt, you do so to uphold a system that protects innocent people from unjust condemnation. You're performing a legal duty that I think is in no conflict whatsoever with your but the code of professional responsibility recognizes that you can advise a client about what the law requires of them and how to avoid criminal activity, but it would be unethical for you to advise someone how to violate the law. That's something lawyers can't do. So I think in the main, when you're following the code of professional responsibility, the likelihood of a real conflict of legal and moral duties is pretty remote. Tougher cases come when you're a divorce attorney and you just are routinely assisting people without regard to any kind of counseling or other kinds of serious thought in obtaining divorces to end their marriages. The Pope has talked about that as a moral dilemma for civil lawyers. I'm not saying that a Catholic lawyer can't practice family law. I'm not saying that, but it is something about which you have to consider your conscience and whether the way you do that practice is consistent with your role as a teacher and a moral role model within the community. I do think you have that obligation.
Well, let's thank our speakers again for their time.